Hello, my name is Tony and I'm inviting you, the viewer, to join me on a journey of discovery where we uncover the truth about employment law and answer your questions. Are you ready? Hello and welcome to another episode of Employment Law, The Truth is Out There, where we uncover all of the myths around employment law and HR. I'm joined as always by Alison Colley from Real Employment Law Advice. Hello Alison, how are you today?
I'm fantastic, thank you.
And are you looking forward to today's question?
Yes, I can't wait to hear what it is.
Well, it is a good one, as always, and this one is around disciplinaries. So we've had a letter in from Steve from Newcastle who said he's been called into a disciplinary at work and he doesn't know what to do or what it's going to look like. So Alison, can you answer Steve's question today?
Yeah, the first thing I want to say is a letter in.
Yes.
That's pretty unusual these days.
I know, we are going old school, I have to say. We are finding it more. And maybe the old situation in England has made people have a bit more time.
Okay, so sorry to take away from Steve's question
Letter.
there, and a very serious issue. So Steve's been invited to a disciplinary. Okay, there are a number of reasons why you might be invited to a disciplinary by your employer, and they can be to do with conduct and they can also be to do with performance. And hopefully Steve's employer has explained to him in his letter why they've invited him to a disciplinary.
So the first thing is what you're saying is when you are invited, it should tell you why.
Yeah, sometimes you might have pre-warning of a disciplinary issue because your employer might have been undertaking an investigation in which they might have asked you questions. But there isn't any guarantee that they will have asked you questions in advance of a disciplinary, so getting the letter might be the first that you know about it. And hopefully your employer will follow the right process and tell you what the allegations are. And in that letter, they should also provide you with copies of any evidence that they have in support of those allegations.
So Steve's received this letter then. What does he need to do next?
Well, if he's got all the information in the letter that he needs, then what he should be doing is reviewing that information and any evidence and preparing himself for the disciplinary. If his employer hasn't provided him with any information, or the allegation is very vague and he's unsure or he's not able to use that to formulate his defence, then he should go back to his employer and say, look, I need some more information about what you're going to be asking me about at this meeting.
The other thing that I want to know is, in relation to this disciplinary, if Steve hasn't got all the evidence, can he go and get it?
Yes, so if he thinks that there's evidence there that may support his defence and he hasn't got access to it for whatever reason, he can ask his employer to produce that. So, for example, if they are using an allegation in relation to something financial and he knows that there's evidence within the accounts or the bank statements that will support his defence, then he can ask them to find that and produce that.
Brilliant. And what happens if Steve's not happy about where the disciplinary is going to take place?
What do you mean, if it's in his office or something like that?
Yeah, if it's somewhere where he doesn't want to be.
Yeah, you can always ask your employer to hold the disciplinary hearing elsewhere if you feel uncomfortable, for example, going into work. So you might have been suspended whilst the disciplinary is pending, and if you feel that it would be embarrassing going into the office to have the disciplinary, you can ask for them to hold it in a neutral location. There's no obligation on them to do that, but you can always ask.
And when should Steve get some actual legal help and support then?
Well, he can contact somebody at the earliest opportunity, really, when he gets the disciplinary, to try to get some advice. I would say if it's particularly serious allegation, then it's worth getting some advice at the earliest stage, because the advice you receive might help you to retain your employment and to defend the case or the disciplinary. And certainly if you get advice from a solicitor, they'll be able to give you some pointers on what to do. So one of the things that I often tell people is to really engage in the process and to start putting together your defence in writing if possible. So if you dispute the allegations that have been made against you, then start writing your own kind of witness statement and putting the information down in writing. Not only will it help you at the disciplinary hearing, but you can provide a copy to the disciplinary panel or to the disciplinary chair before the meeting, and that will really help you to sort of formulate your response, because often when you're in a meeting you'll forget things or you become flustered and you may not say everything that you want to say.
And how much is it going to cost Steve then to give you a call and speak to you through his disciplinary?
So it's free to call us and have an initial chat, and we'll talk you through the issues. And if you're unsure about the allegation, or if you think that it's something that you have done wrong, and you're worried that you might be dismissed for it, we can talk you through whether we think that that would be a reasonable thing to dismiss you for. And we can also help you in terms of, formulating a response and that kind of thing. So the initial call is free, and thereafter we charge at an hourly rate, and we'll give you an estimate of our costs, or you can set a limit on the costs that you want to spend. Certainly that's what we can do for you in a disciplinary situation. I think it's really important if you are invited to a disciplinary, and what people often forget is to ensure that you try to remain calm and engage in the process with your employer. Even if you fully dispute what's being said, it's not going to be helpful for you in the long run if you become unreasonable or you refuse to attend meetings and that sort of thing. So often people will try to delay the meetings, the disciplinary hearings, and whilst that might be okay if you need to formulate your defence or get someone to attend with you, you can't let it drag on, is really what I'm saying. Is you should really engage with your employer and deal with the process as best you can.
Yeah, no head in the sand.
Yeah, absolutely. And sometimes people go to disciplinary hearings and they become aggressive towards the people there. And again, that doesn't help your case in any way, even if the allegation is completely spurious against you and there's no evidence for it. You still need to behave in a reasonable manner with your employer, remembering that you've got to have that long-term relationship with them.
And one last question that I've got is, can I take you to my disciplinary hearing?
You can ask your employer to take a solicitor to a disciplinary hearing. The law requires your employer to allow you to be accompanied by a work colleague or trade union rep. So your employer can't refuse one of those to attend. They can allow you to be accompanied by a solicitor or someone else. You'd have to ask your employer. In my experience, however, most employers don't want a solicitor to be attending with you, and quite often they will refuse. There have been occasions where I've seen it happen and they've let a solicitor attend, but otherwise, in most cases, they won't. But you can always ask.
Brilliant. So hopefully that's answered Steve's question. Is there anything else you want to add before we go today on disciplinaries?
Only just to say, is really in relation to what happens after the disciplinary. So if you are given a warning or you're dismissed because of a disciplinary, then your employer should give you the opportunity to appeal. And I always recommend that you do appeal against it if you are dismissed in particular. And again, we can help you with that if you need to.
Brilliant. Well, Steve, hopefully that's answered your questions today on employment law. The truth is out there. And remember, watchers, as always, stay legal.